Good morning, everyone, and thank you for joining us. Today, we are unpacking the right to disconnect changes that will affect small businesses as of 26th of August this year. My name is Christina Jakob, and I'm joined by my colleague, Abby Smith. Welcome, Abby.
Thank you. Good morning, everyone. Thanks for having me. I'm an advisor in the Employee Relations Helpline here at CCI.
Yes, and together we're really hoping to help you understand those new changes for small business employers. But before we do that, I'd like to take a moment to acknowledge the traditional custodians of the land from which I'm presenting today. We pay our respects to the Whadjuk people of the Noongar Nation, both past and present. So before we get fully started, this is our disclaimer to let you all know that information presented in this session is general in nature and it's not legal advice. But if you have any special circumstances that you're dealing with, we do have a team of workplace solicitors here at CCIWA. So please let us know. There's going to be some contact details at the end of this session. So if you can reach out on those, they would love to give you a hand. And so before we get started and dive into the content, if you're listening this morning thinking, oh, well, this change is not entirely new. I've heard about this. Why are you saying it's new? Oh, well, you're kind of right. It's not entirely new. This right has already been introduced for medium to large organisations from 26th of August last year. But today we're talking about the changes that will affect small business employers, and Abby is going to talk a little bit more about that in the next couple of slides. But I just wanted to highlight the fact that this webinar is strictly for small business employers that have not had to deal with the changes so far. And so here's what we're going to cover in today's session. We've got a number of things listed on our slide, such as we're going to start with an overview of the right to disconnect, changes under the Fair Work Act, how this actually interacts with other legislation, including risks and other considerations. What is considered reasonable, because that's always a question that pops up, because it's very hard to identify what's reasonable in circumstances. Any proactive steps that you can take to make sure that you stay compliant, recommendations. I will also have a really interesting case that's quite recent where the right to disconnect was mentioned. And then lastly, we will go through some questions. So if you've got any questions as we go through the slides, please make sure that you pop your questions into our Q&A session so we have enough time to answer them at the end. Thank you.
Alrighty. So, I mean, it's probably safe to say that the right to disconnect was probably one of the most controversial changes that was introduced with the Closing the Loopholes #2 bill.
Absolutely.
Or at least the change that has received the most amount of media attention since it's come into effect. The Fair Work Legislation Amendment Closing Loopholes #2 Act 2024 introduced this right for all national system employees, and it's now part of Section 333M through to W of the Fair Work Act. The right has been in effect since, like Christina said, the 26th of August last year for medium to large businesses, but for small businesses, so if you have less than 15 employees, including casuals, this will come into effect on the 26th of August this year. So you've been given an extra year to get ready and adjust to that change. Christina, what was your first thought when this change came in for those medium to large organisations?
Well, I think I reacted in a very similar way to most people. It was a bit of a wow, you know. But then as I looked into it, I thought, okay, so what are the implications? What are the risks? Let's just try to understand this right. But the reality is that with technology advancing and flexible work arrangements like working from home becoming increasingly more popular, the lines between personal life and work life have become increasingly blurred. And so this right is really designed to give the employees that choice to disconnect after hours, of course, in reasonable circumstances. And it's certainly a new concept, and I do think that it frightened a few employers out there. And that's because it challenges those long-standing norms of around availability and responsiveness. And so what is this right, Abby, and how is this going to affect businesses? This slide really provides us with a bit of an overview, but Abby, if you can just explain that to us in simple terms, that would be great.
Absolutely. So look, in simple terms, it means that an employee can now ignore contact or refuse to monitor, read or respond to messages or communication sent to them outside of working hours. So this could be calls, text messages, emails, any of those kinds of communication. So long as the behaviour is not unreasonable, and you also can't discipline or take adverse action against them for exercising this right. The right to ignore also extends to third parties such as clients or customers, so just keep that in mind. However, bear in mind the changes don't mean that you're now prevented or a third party is prevented from ringing an employee, texting them or emailing them outside of those hours. The right to refuse cannot be exercised if the refusal is unreasonable, and the legislation does provide us with some guidance around what might affect this test, which we'll get into a little bit later. So a question we often hear is, can I still contact my staff outside of their shift or outside of those ordinary hours? Yes, you can. However, employees have the right not to respond, especially where that refusal is reasonable. And we'll discuss this in more detail in connection with some cases a little bit later on as well.
Absolutely. Thank you, Abby.
All right, so what is considered unreasonable? So the term unreasonable appears quite a lot in the Fair Work Act, and unlike other circumstances, we do actually have some specifications this time, and the Fair Work Act does actually offer some direction and provides us with a non-exhaustive list of factors to consider when determining whether it is unreasonable or not. The factors are designed to help employers navigate the changes, and it's really crucial for you to familiarise yourself with these changes as they will impact a wide range of different businesses.
So what are those factors, Abby? We do have all of them listed on the slide for you, but Abby's going to go through them one by one. Thank you.
Let's run through them. So non-exhaustive again, so it's not the be all end all this one, but first one being the reason for the contact or the attempted contact, how that contact or attempted contact is made, and the level of disruption that the contact or the attempted contact causes the employee. It's such a mouthful, all of that. The extent to which an employee is compensated. So this is probably one we see also questions coming through a lot as well. So it's looking at how much they're compensated to remain available to perform work during the period in which the contact or the attempted contact was made, and for additional working hours outside of the employee's ordinary hours of work. So the right to disconnect, remember, will apply to all employees regardless of their pay. So employers can't just ignore this right based on an employee having a huge salary, for example. However, the nature of the employee's role and that level of compensation will help in determining if exercising that right to disconnect is reasonable in specific situations. So again, another possible factor in this as well, like we just said, is the nature of the employee's role and their level of responsibility. Say, for instance, there's an urgent matter or an emergency, it might be reasonable to expect an employee to respond, but with non-urgent matters, it's probably more reasonable to expect them to disconnect in those instances. And that last reason is also personal circumstances. So do they have a family? Do they have caring responsibilities? Is it reasonable to expect a response at certain times in the day, given those personal circumstances as well? So I guess an example would be, it would be really unlikely for a doctor who is on call to be reasonably refuse a contact attempt, but depending on the circumstances, it might be reasonable for someone who's, say, a casual or someone who's contracted as a 9-to-5 employee. That would probably be more reasonable.
Yes, absolutely. Another example that I can think of is if you have, say, a consultant and you're expecting a really important project delivery over the weekend, you have a discussion with them, you tell them, hey, you know, we've got this project, you really need to remain available. They agree, they say, yeah, sure, no problem. And then they miss that call and they miss that delivery, and that has a huge impact on the business. So in that particular circumstance, you may be able to argue that out of hours contact refusal was unreasonable. So it's going to depend on the circumstances and those factors that Abby has just listed for us. So let's look at a few other examples. We've got a few examples listed there on the slide for us. So Abby, can you please take us through those?
Sure can. So for example, offering a shift. So again, maybe you've got casual employees, someone calls in sick, you're going to need someone to cover it. It's absolutely reasonable to reach out and offer a shift and to an extent to expect a response. However, because they're not at work, it'd be unreasonable to discipline or punish them if we don't get a response regarding that shift and if they can cover, because obviously they're not at work at that time. So again, nothing to say you can't reach out and offer it, but taking actions if you don't get a response is going to probably be quite limited. If there's a workplace emergency or a disaster, so again, it could be reasonable to contact employees and expect a response in those urgent situations. But again, depending on the scenario, it might be unreasonable then to penalise employees for non-responsiveness.
Absolutely.
Changing travel or work plans. So again, if there's been a change in plan and you're needing to get hold of them, similar to what we've just said, it's reasonable to maybe expect a response in those changes. But again, depending on the urgency or the impact that those changes will have, punishing employees for a non-response, again, might not be doable because they weren't at work at the time. So to expect that response might not be viable. Now, where it's slightly different is what if you've got maybe a major incident on site, you've got your emergency contact, your employee who's on call. Now, it's reasonable to expect on-call employees to respond promptly to situations. Bear in mind they should have the right to opt out if they are on leave or if they are sick. And it's also good as well to have multiple emergency contacts in these circumstances to ensure timely responses. But again, normally with people on call, they're receiving some extra allowance if we're covered by an award. So a response in those circumstances would be expected and they wouldn't be able to exercise that right to disconnect necessarily. And I guess another example as well, what if we're looking to hold a performance management meeting with an employee and we're requesting it to take place outside of those working hours? It may be unreasonable because it's not aligned with the employee's normal work schedule. So if you're reaching out trying to organise those sorts of things, we probably shouldn't be expecting a response, and we should respect the employee's usual work times and those rest times as well.
Thank you, Abby. That's absolutely right. So as you can see, there's no one size fits all. It's all going to depend on circumstances. You really need to look into those factors and the risks before you make a decision. So now, what does outside of work hours mean? This has always been a very grey area for us. It's just very unclear. Really, again, depends on circumstances and reasonableness. So could you please explain to us the term working hours for us, Abby?
For sure. So look, the term working hours, as Christina just said, that it's really broad. It can cause quite a lot of confusion. But basically, it's describing an employee's working arrangements, such as their ordinary hours of work. So this means that in the context of right to disconnect, an employer can freely communicate with an employee during all of their working hours. This would include your ordinary hours and also overtime hours that are agreed to as well. And an employee's refusal to monitor, read or respond to communications during that time won't be protected by the right to disconnect. However, once those working hours cease or they finish, an employee can then elect to exercise that right to disconnect. So in many employment contracts, it is specified that an employee's annual salary includes compensation for that reasonable additional hours that we see. This is especially true for employees not covered by enterprise agreements or modern awards. With the right to disconnect, the Fair Work Commission must also consider whether an employee receives compensation for extra hours of work or for being on standby, like we were saying earlier, outside of those regular hours when dealing with out of hours, whether those are that communication is unreasonable or not. Employers should include detailed clauses in contracts to clarify expectations about after-hours contact and the related compensation, so showing that clear link that extra compensation does cover for those out-of-hours contact and what that could look like, just to show that it will help in those instances where people might be trying to exercise that right and it's not the right time to be exercising that. Also, be clear with your employees about that requirement to handle after hours contact as part of their role and specifying the compensation for these duties, like we just said. Again, like we said, it makes it more reasonable that the Fair Work Commission likely that they're going to find that that contact attempt was reasonable.
Absolutely. And so your position descriptions, should really be up to date, and now it's a really good time to review them. And if you wish to add any other additional duties or clarify anything, make sure you do that now. That should also be linked with your contract of employment. Like Abby said, if you want to add an offsetting clause, that's a really good idea, but make sure that you get some legal advice on that. And also, if you want to add additional duties, or if you expect them to remain available outside their work hours, that expectation must be reflected in their compensation as well. So you really want to do those boot calculations for worst case scenarios, and to make sure that you factor that into the rate of pay, into the salary. And that's really crucial, because failure to do that can really lead to underpayments, including wage theft. Some new provisions about the wage theft have been introduced in the Fair Work Act recently, so you really need to just understand those risks as well. And also, it's crucial to identify the correct underpinning industry and occupational award. So if you need assistance with that, our advice team can certainly help you with advice over the phone. So please do reach out, because failure to identify the correct industry award can really lead to underpayments. Now, disputes always come up, no matter how perfect your processes are. And so disputes can occur because of a number of circumstances, some of them including if the employer believes that the employee's refusal is unreasonable in the circumstances, or if there's a disagreement between the employer and the employee about the reasonableness of that refusal, or otherwise if there's some sort of argument about how the right to disconnect should be applied. So what is your recommendation about how to reach an agreement and the dispute resolution process internally, Abby?
Yeah, absolutely. So look, in the event that a dispute arises in relation to, like Christina was saying, an employee's refusal to be contacted outside of those working hours, the legislation requires that the dispute must first be discussed at that workplace level. So you've got to try and solve it internally before taking it to the Commission. So have that workplace discussion, discuss the incident at that workplace level, so between yourself as the employer and the employee affected. See if you can come to a resolution between those two parties. If that doesn't work, that's when we're going to have to escalate it. So if there's no resolution reached at that level, either party can apply to the Fair Work Commission for a resolution. So that could come from your employee, or it could come from you as the employer as well. That's when Fair Work are going to get involved. So the Commission can make an order under Section 333P to either stop the refusal of contact or take other necessary actions to resolve the dispute. The Commission will be able to make an order to deal with it as they consider appropriate, and it could be in ways other than ordering the payment of an amount. So it could be through mediation, or it could be through conciliation as well.
Now, let's talk about stop orders. So the Fair Work Commission can make a stop order if an application is made in the following circumstances. And we've got those circumstances listed on the slide for you to read as well. So if an employee has unreasonably refused to respond to contact and might continue to do so, or if an employee's refusal to respond is reasonable, but the employer continues to either contact them or perhaps decided to take disciplinary action against them. So if these conditions are met, then the Fair Work Commission can make an appropriate order to either prevent the employee from unreasonably refusing to contact, stop the employee from taking any sort of disciplinary action against them, or otherwise stop the employee from requiring the employee to respond. And so the Fair Work Commission must handle the application within 14 days and as quickly as possible. And they can dismiss the application if it's a frivolous or vexatious application, or if it involves any matters in relation to national security or police operations. So if an employer thinks that the application is frivolous or vexatious, they can make an order to the Fair Work Commission, and the Fair Work Commission can deal with that appropriately.
And out of curiosity, what is the effect of these orders?
Thanks for the question, Abby. So if an order is made, then a person must not contravene that order for sure. And the penalty for contravention is 60 penalty units. And so the one penalty unit is actually $330, and that's changed from November last year. So all up, the amount would be about $19,800. So, you know, it can still have quite an impact for small business employees for sure.
Definitely.
And so this slide really just summarizes what we've said. And if you're a visual learner, this flowchart hopefully explains the process in a bit more detail regarding what can happen if disputes can't be resolved at workplace level. Again, it's ideal that you try to resolve them at workplace level, but if that's not the case, both parties can reach to the Fair Work Commission for assistance. Now, this is the case that I've mentioned earlier that I would like to share with you. It's quite a recent case. Michelle Martin versus Cairns Rudolph Steiner School. So the applicant, Miss Michelle Martin, was a teacher at Cairns Rudolph Steiner School in Queensland, and she filed a general protections claim under the Fair Work Act after her dismissal in October last year. And she alleged that her termination was connected to her exercising a number of workplace rights, with the right to disconnect just being one of them. However, her application was one day late, was filed one day late, and that raised a jurisdictional objection. And so to proceed, she needed to apply for an extension, which she requested on the basis of a miscalculation by her solicitor. So the Fair Work Commission considered a number of factors, including the reason for the delay, which in our circumstance happened to be her solicitor's errors, not hers, and her timely intent to challenge that dismissal, and found the delay to be minor, the circumstances to be exceptional, and therefore they decided to grant the extension, allowing the case to proceed and reinforcing the fact that applicants should not be penalised for their representatives' mistakes. And so let's have a look at the details of the actual case and how it all unfolded step by step. It all began in January when the applicant raised a concern with the school about a contractor that was working at the school. And according to Ms. Martin, that complaint set the wheels in motion. Then things escalated. She was allegedly excluded from a meeting and received a formal warning, action she believed to be adverse action. By March, she lodged a formal grievance through her union, the Teachers Professional Association, seeking to have her concerns addressed properly. By June, the school had completed an investigation into those concerns raised, and they dismissed the grievance, citing a lack of supporting evidence, and they also scheduled a meeting, not only to address the facts from that investigation, but also to discuss other management type of issues, such as misconduct by Ms. Martin. In July, she attended a meeting and she was directed to undergo an independent medical review. So she did that in August, and the psychologist's recommendation was very clear. Avoid anything that would exacerbate her stress and any sort of any sort of action that could lead to disciplinary action. And the school complied with that, and they waited more than 2 weeks before issuing a letter with allegations and a warning of a possible disciplinary action. Her solicitor, by that stage, she reached out to get legal advice, responded on her behalf to say that she was actually on school holidays and requested an extension on those grounds. The school disputed that, saying that she's not on school holidays, but they still allowed a bit more time, but not as much as the solicitor initially responded. There's been a bit of back and forth between the parties, but eventually Ms. Martin didn't show up for the meeting, and the school then decided to terminate her on the basis that she failed to attend that disciplinary meeting and to respond to those allegations made against her regarding a repeated pattern of inappropriate and unacceptable behaviour. And so, which she claims that was sent on while she was on school holidays. Now, the school denies all allegations. They deny that they broke her right to disconnect or took adverse action against her. But because the matter could not be resolved through the Fair Work Commission, now she has filed an application for general protections under the Fair Work Act, and she is actually seeking a very high amount, over $800,000, including $50,000 in hurt and humiliation. So that is an eye-watering figure for sure. And so we are now going to have to wait to see what the employer's version of events will be. That could maybe taking, maybe 12 months to 24 months. That's how long those general protections can wait for an outcome. But certainly I do want to clarify that misconception. Simply contacting someone outside their work hours does not breach their right to disconnect, and you're certainly not going to end up with a legal claim just because you've reached out. They don't have a legal claim just because of that, but what the right to disconnect does, it empowers the employee to choose not to respond. It doesn't stop the employee from reaching out unless there's a stop order, but in our case, there was nothing like that.
Mm-hmm.
And so how do we navigate the right to disconnect in a flexible world? And so as we embrace more flexible ways of working, we really need to rethink how we actually manage those boundaries, especially when it comes to out-of-hours communication. And so start by reflecting on your out-of-hours communication habits. Ask yourself, could this message be seen as unreasonable if received? And if your answer is yes or maybe, it's time to do something about it. Other things that you can include automatic replies, maybe delay the delivery, or you can just have something in the signature of everyone, my working hours are, etc. But I guess, if you're reaching out of hours, make sure that you clarify what your intent is. If your intent is not for them to respond then and there, make sure you clarify that. Because if you're saying something like, please give me a response by the end of the day or ASAP, well, that means that your intention is for them to respond then and there. So just try to pay attention to the wording of your emails. Also, make sure that you have some really good, clear, tailored policies and procedures to define what the right to disconnect is, to clarify what reasonable contact is. Maybe you want to clarify emails, text messages. They might not require an immediate response, but if it's a call, that's likely urgent. Make sure you've got an internal dispute resolution process, and try to implement a right to disconnect policy. Here at CCR, we have already developed one. It's already in place and ready for purchase, and we have currently discounted it for small business employees, so please do reach out if you are interested. You may be wondering, why do I need policies and procedures? Well, without clear policies and procedures, your managers are left in the dark to interpret those expectations on their own. And so that can lead to inconsistencies, confusion, and even conflict. So, and if leadership talks about valuing work-life balance, but they don't actually back it up with action, that really just creates that cultural disconnect and erodes the trust and morale in time. Mm. Another thing that I want to suggest really quickly before we wrap it up, train your managers and supervisors. They really, they are the ones at the forefront of your workforce. So let's be honest, they don't really understand what this is. They're not trained enough to manage all of these and to understand the legal consequences. So make sure that you reach out if you want us to come along and provide some training for your managers and supervisors. That can really help to make sure that you stay compliant. Review your contracts, and also finally lead by example.
Definitely.
That is really important, just to make sure that you set that tone from the top. And now we've reached our half an hour. We would like to ask you to please take a moment to scan this QR code to complete this survey regarding how this IR reform could impact you and you as a small business employer. And once you've done that, we will be ready to take questions. Before we do take questions, just a quick summary of how we can actually help. We can help you here by reviewing your contracts of employment. We can even do red flag reviews, either through our legal department, or the advice can do them for free as well. We can help you with training for staff and management. We've got a number of training sessions available, so please do reach out. We can even come to your site. right to disconnect policy, award allocations, and they're the ones where we do an assessment to try to identify the correct industry and occupational award for you. Here's how you can stay connected. Please visit our page and check out training programs. We do have a number of other free resources coming up, so make sure that you check that out.